Father's request to modify timesharing. In Florida, the default timesharing setup is an equal sharing of time, since it is presumed that parents should equally share the joys, responsibilities, and rights of raising a child. This default can be deviated from when that would be in the best interests of the child, i.e., equal time sharing would be detrimental, and/or the parties agree to it, as the parties' agreement can be adopted into a dissolution of marriage order as it was here. When a dissolution of marriage order includes provisions regarding timesharing, those provisions may be modified upon a showing of a substantial change in circumstances from the time when the order was entered. Mother's request to modify child support. Like with timesharing, modification of child support also requires showing a substantial change in circumstances. A change in income that would lead to a 15% or $50 increase in child support obligations is typically found to be a substantial change in circumstances. If mother is correct and father's income has nearly tripled, a 15% or $50 increase would likely be found, and the court would likely grant modification of the child support order to have father pay more child support. Notably, child support is intended to put a child in a position to receive the same split/amount of resources from the parents as the child would if the parents had remained married, a goal which would be met by increasing the child support father must pay if his income has come anywhere close to tripling. The beneficiary of child support is the child, so parents may not waive child support on a child's behalf nor agree to a reduction below the amount to which a child is entitled. The anti-modification clause would result in the latter since it would prohibit child support from being increased to be congruent with child's needs and best interests. Mother's request to modify alimony. As an initial matter, unlike child support, alimony is a spouse's benefit to waive, so the clause prohibiting modification may be enforceable to prevent mother from modifying alimony. Such a clause may be enforceable if it is reasonable and agreed to by both 20 parties, both of which appear to have been here. If the anti-modification provision is not enforced, mother may be able to modify alimony if she can show a substantial change in circumstances has occurred since the order set the alimony. Since alimony is largely based on a balance between the payee spouse's need and the payer spouse's ability to pay, father's alleged large increase in income would qualify as a substantial change in circumstances. Alimony. Florida allows several types of alimony. Whether and in what amounts alimony is awarded depends on several factors, including the length of the marriage, the standard of living during the marriage, the parties' respective financial positions, the parties' respective ages, the parties' respective contributions to the marriage, including childrearing, the parties' levels of education, and whether the parties sacrificed career and/or educational opportunities during the marriage to contribute to the marriage. Pendant light alimony, discussed below, can be awarded during litigation to make sure the spouses are on equal footing. Bridge the gap alimony is awarded to help a party transition from married life to single life. That likely would not apply here since mother has been single for 8 years, since the party's original dissolution of marriage, so she is not in a transition period. Another type of alimony is rehabilitative alimony, which is awarded to help the payee spouse obtain the education, job training, etc. necessary to become self-supporting. The facts do not suggest that there has been a substantial change in circumstances that makes the education and job training mother has less sufficient for her self-support now than it was when the dissolution order was granted, so the court is unlikely to modify the order to newly grant rehabilitative alimony. If neither of those types of alimony are appropriate, a court may award permanent alimony, but this is usually only awarded for marriages of long duration, those lasting more than 17 years. Mother and father had a marriage of moderate duration, 7 to 17 years, since it lasted 9 years, so permanent alimony is unlikely to be awarded, especially considering the facts do not indicate there is an overwhelming need. If none of the above types of alimony fit at all, a court may grant durational alimony, which is alimony lasting for the same length of time for which the marriage lasted. Mother's request for attorney's fees. If an agreement incorporated into a dissolution of marriage order contains provision for attorney fees to be paid by one party to another, such an agreement is enforceable if reasonable. Father's attempt to modify timesharing in Georgia court and application of UCGIA. In order to modify a court order regarding custody, including timesharing, as is at issue in this case, of a child, a court must have jurisdiction. In states that have adopted the UCCJEA, as Georgia, GA, and Florida, FL, have under these facts, the UCCJEA controls what state has jurisdiction. Under the UCCJEA, a court that originally issued an order has exclusive continuing jurisdiction to modify that order. Divorce. In Florida, divorce will be awarded if the marriage is irretrievably broken. Florida is a no-fault state and the grounds for divorce need not be any more than an irretrievably broken marriage. If both spouses agree the marriage is irretrievably broken, the court will likely award the divorce without hesitation on this cause. However, if one party believes the divorce to be irretrievably broken and the other party claims otherwise and/or request counseling, the court may, within its broad discretion, either order counseling prior to awarding the divorce, or may continue the proceedings to allow time for the parties to cool off and rethink the marriage prior to awarding final judgment. When a couple is divorced, the judge will further distribute property in an equitable manner, see below, and order alimony, child support, and custody, if applicable. Divorce petition. The divorce petition will need to contain the grounds of the divorces, as spoken about above. It must establish jurisdiction, discussed below, the request of the parties, how they would like the judge to rule, and a signature attesting to the truth of the statements within. Jurisdiction is determined based on where the parties reside. If the parties reside in separate places, the court in which the parties were living for 6 months or more at the time of filing will be valid jurisdiction. If there are children involved, the children's residence will be the likely residence for determining jurisdiction, if they have lived there for more than 6 months. If they have not lived there for 6 months, the proper jurisdiction will be the previous place of residence in which they lived for more than 6 months. With the divorce petition, the filing party will have to attach any relevant supporting forms and receive a summons from the court to order service upon the other party. The other party will need to be served within 90 days of filing, and the filing party will need to file the certificate of service once completed. The divorce should be filed in a county court. Premarital agreements. Premarital agreements are essentially a contract between the parties regarding how a divorce will be handled. A contract may be oral unless it is for certain things that fall under the statute of frauds. Marriage agreements do fall under the statute of frauds, which means it will need to be written. The writing will need the essential terms, the parties, and a signature of the party to be charged. A premarital agreement may contain any agreement the parties choose as long as the agreements are legal. The agreements will be invalid if made under duress or fraud. Further, child support cannot be waived as it belongs to the child, not the parent. Alimony may be waived, but the court will not allow this waiver if it will act to put the spouse in need on state welfare. Alimony. In Florida, there are a few types of alimony, including pendant light, alimony during the divorce proceedings, rehabilitative, alimony to allow the spouse support while renewing any necessary licenses or work skills needed to support themselves, bridge the gap, alimony to allow time for the spouse to transition from being married with financial support to being single and self-supporting, durational, alimony to allow for support for a specified period of time, permanent, alimony for the duration of one's life or, typically, aid until the receiving spouse marries or lives with a supporting partner. When alimony is determined, it is based on a need and ability. In determining if the court should award alimony, the court will look to the party's need for financial support and the other party's ability to pay the same. The court would further look towards the length of the marriage. A marriage of less than 7 years is considered a short-term marriage, a marriage of 7 to 17 years is considered a mid-length marriage, and a marriage of longer than 17 years is considered a long-term marriage. Typically, duration alimony and permanent alimony will not be awarded for a short-term marriage unless there are exceptional circumstances. A mid-term marriage may be eligible for all but permanent marriage, depending on the circumstances, unless exceptional circumstances apply. Durational alimony, rehabilitative alimony, and bridge the cap alimony will have a set end time. Rehabilitative alimony will require the party in need to have goals and expected deadlines in which to accomplish those goals, and that will help the court determine the length, not to exceed 2 years, of the alimony. Child custody and support. When two parties have children in common, the court will determine, if the parties cannot agree, legal and physical custody. Legal custody generally starts at joint legal custody and will only be changed if the judge finds it to be in the best interest of the child. Physical custody will come with a parenting plan to ensure the parents each have access to raise and care for their child. The physical custody and the parenting plan, if not agreed upon by the parties, will be determined by the court using the best interest of the child factors. The court enjoys broad discretion over these matters, and the order will not be overturned on appeal unless there is a showing of abuse of discretion. The appeals courts shy away from overturning family law orders because the presiding judge will best be able to determine the relevant factors as they see the parties in person and know their local area and needs best. Child support will be determined based on state guidelines. Any deviation from the guidelines by more than 5% will require the judge to show finding to support the deviation. Equitable distribution. Florida follows an equitable distribution framework. This does not always mean equal. The court will do its best, if the parties cannot agree, to equitably distribute all marital assets and return non-marital assets to the party who owned them when entering the marriage. Marital assets include any asset the couple obtained together, or assets one spouse obtained during the marriage. Exceptions apply, such as a non-marital gift or assets devised to one spouse only. Typically, any assets brought into the marriage will be distributed back out to the spouse who entered with that asset. Some exceptions apply. For example, if a spouse comes into the marriage with a house and the house is improved during the marriage or used as the marital home, this will likely be distributed equally among the parties. At the very least, the court will distribute any increase in value equally among the parties. A further consideration to be made here is Florida's Homestead Act. Any property that is used as your primary residence will be protected up to 160 acres of contiguous land, if outside of a municipality, and any home on that land or up to 1 acre of land and home if it is in a municipality. Under the Homestead Act, not only are the parties protected from certain creditors, with exceptions, the parties are protected from the spouse selling the home without the other spouse's permission. This right can be waived in a premarital agreement. Mediation. Mediation is a form of alternative dispute resolution and may be used in place of a court proceeding. Their attendees will be the parties and their lawyers and a neutral mediator. Any offer or statements in mediation are confidential and cannot be used in court unless discoverable some other way. Fees. A spouse may ask the court to award the other spouse to pay their attorney fees if they are unable to do so, and the court may validly order the same. If the husband is awarded pendental light, this likely will not be awarded because he will already be using support money to pay for these fees. Otherwise, he may be awarded fees in this case if he can show a need and the other's ability to pay. Homestead property. Homestead property requires that a person have a qualifying ownership interest, legal or equitable title, must be a present interest, and the home is used by the owner or their dependents as their primary residence. Homestead property is limited to 1/2 acre within a municipality and 160 contiguous acres outside a municipality. A married owner of homestead property may not alienate, encumber, or devise the property without his spouse's consent to anyone but their spouse or minor child. The spouse will take a life estate with a vested remainder in minor children per stirpes. Or the spouse may elect to take a 1/2 interest as a tenant in common with a minor child. Homestead protections last until it is abandoned. A person abandons their homestead when they have another permanent residence. Homestead. Homestead property is protected from forced sale from creditors unless it fits into an exception for mortgages for the purchase or improvement of the home, taxes due, or construction liens. Tenancy by the entirety. One tenant may not encumber property that is held as a tenancy by the entirety without consent or being joined by their spouse. Creditors of one spouse may not reach property held as a tenancy by the entirety by both spouses. Divorce severance. As stated, a divorce terminates a tenancy by the entirety and creates a tenancy in common. Divorce will not terminate Hank's homestead protections so long as he continues to reside in the home. Homestead exemption. As an initial matter, Florida has a homestead exemption. This exists when a homeowner is a resident of Florida, and the property in question is either his dependent's primary residence. The exemption protects the homestead from forced sale in a foreclosure. However, the exemption does not exist for purchase money mortgages on the property, or other loans, mortgages, and construction liens used to improve the property, or actions after the failure to pay property taxes on that property. This exemption affects many of the interests on the loan. Termination of parental rights. Termination of parental rights is considered a serious action and will be presided by a judge and fully adjudicated even though it is a civil proceeding. The circuit court will have exclusive jurisdiction over such proceedings. Parents facing a TPR are protected by the Due Process Clause of the United States Constitution and by Florida Constitution. The U.S. Constitution guarantees parents facing a TPR the right to counsel, goes beyond statutory right under Florida. Further, the government must prove its case in a TPR by clear and convincing evidence. This is a higher standard than the preponderance of the evidence standard required during shelter and dependency proceedings. During a TPR proceeding, notice must be given to parents, to grandparents, to guardians, and to any other that has possible custody rights to the children. If the state effectively files a TPR petition, that parent's rights will no longer exist, and in the face of the law that parent will have no legal relationship to that child. TPR is an individual process, and as such each parent is independent of each other. Filing of termination of parental rights. A TPR may be filed at any time. However, in Florida DCF must file a TPR when 1. Parent has been under a case plan for more than 12 months and not met the requirements, 2. The children have been dependent for 12 months out of the last 22 months, 3. When parent has killed or attempted kill other parent or children, 4. When parent has been sentenced to incarceration, which will last through the substantial part of the child's youth, 5. Parent has failed to comply substantially with case plan and 6. When it finds that there is good cause for initiating the proceeding. TPR can occur because a parent has abandoned the child, for abuse, for neglect, but this must be shown by preponderance of evidence. Adoption of children. In Florida, anyone can be adopted, including adults. Adopter can be either 1. Married couples, 2. Individual adopting as single parent, and 3. A spouse adopting the biological children of his spouse. Consent for an adoption is required by 1. The parents, 2. A child if they are over 12 years of age, and 3. State or guardian of child. Parental consent is not required if the parent's rights have been terminated, or alternatively if that parent never acknowledged paternity and the child was born out of wedlock. Abandonment of the children can go towards showing abandonment if parent never stayed in touch with children. Importantly, the Supreme Court of the United States, with Florida following this ruling, has held that when a child is born during a marriage, paternity by the husband is presumed, regardless of whether he is the actual biological child of the children. Alimony. The marriage lasted 2 to 3 years. Such a marriage is considered to have been of a short duration under Florida law, pursuant to which marriages under 7 years are short duration, marriages longer than 17 years and long duration, and everything in between is a moderate duration. Short-term marriages normally do not qualify for permanent alimony, and, where they qualify for durational alimony, the the duration is typically limited to the duration of the marriage. The other common type of alimony is bridge the gap, which helps a dependent ex-spouse adjust to single dom, but which is limited to 2 years in length. Adoption. In order for an adoption to take place, the biological parents' rights must be completely terminated so that the adoptive parents are able to legally adopt the child. Legal adoption means that for all intents and purposes, the child becomes the biological child of the adoptive parents. The adoptive parents have all the same legal rights to the child as natural parents, such as the fundamental rights to raise the child as they see fit, and the ability of the child to take from his parents under intestacy statutes. The biological parents lose all rights to the child, as if the child never was born to them. Termination of parental rights. In order for this action to take place, there must be a hearing to terminate parental rights prior to the adoption. Under Florida rules, biological parents are entitled to due process for this proceeding. This means that they are entitled to an attorney at all stages of the parental rights termination, and they are entitled to notice of the hearing. If the biological parents cannot afford an attorney, the state will provide one for them. The parents are each entitled to a separate attorney, and a guardian ad litem is appointed to represent the best interests of the child. If the biological parents choose to, they may knowingly, intelligently, and voluntarily waive the right to counsel either on the record in court, or in writing signed by 2 witnesses. At the time of the proceedings, each parent is also entitled to notice to attend the hearing. Parental rights, fatherhood. In Florida, there is a presumption that a child born during a valid marriage is the biological child of the husband. The only way to rebut that presumption is to show impossibility, such as the father being unable to have children or the father not being around at the time of conception. If the child is less than 6 months old, this includes helping the mother with her pregnancy, aiding in the payment of hospital bills, and assuming responsibility for caring for the child. If the child is 6 months or older, the father must take substantial steps to establish a relationship with the child. The court will look to the amount of time the father spent with the child given the father's work schedule, the amount of support the father gave the child, the amount of time spent communicating with the child outside of visiting the child, such as telephone calls, Skype sessions, etc., and whether a relationship between father and the child was actually established. Adoption. After Obergefell legalized same-sex marriage, same-sex couples became entitled to many of the same fundamental rights as heterosexual married couples, such as the right to marriage, divorce, and adoption. Even before same-sex marriage was legalized, same-sex couples were entitled to legally adopt a child. In determining whether a person is able to adopt a child, the court looks at the fitness of the person to be a parent, his/her home environment, his/her work schedule, his/her ability to provide for the child, and many other factors. Adoptions may be granted for married couples or single parents. When a person/family applies to adopt a child, the state conducts a background check on all members of the household who are aged 12 or older. After the background check comes back clear, the state then interviews the parents-to-be and conducts a home study to ensure a safe environment for the child. Following a successful home study, the parents wait until a child is placed with them. The child is placed with them for a period of time, generally around 6 months or longer, to ensure the match is a success. This time is called adoptive placement, and during this time, the parents-to-be and the child make sure that everyone is happy with the placement. The state makes routine checks on the child to ensure everything is going well. Finally, once the placement seems appropriate, the parents-to-be may petition for the adoption to be finalized. The judge generally grants this petition in chambers, so long as it is clear that the adoption is in the best interests of the child. Jurisdiction. Generally, a court will have subject matter jurisdiction over an action for dissolution of marriage if the petitioner has been a resident of the state of Florida for 6 months prior to the filing of the petition. Venue will be proper in the county where the parties last resided as husband and wife or in the county where they live at the time of filing. Grounds for dissolution of marriage. If the husband is not successful on challenging the court's subject matter jurisdiction, the wife's petition for dissolution of marriage will proceed. Florida is a no-fault divorce state. As such, there are only 2 grounds for divorce: the marriage is irretrievably broken and mental incompetence of 3 years or more. As there are no facts to indicate that mental incompetence is an issue, only the first ground applies here. Since the husband does not wish to get a divorce, he may deny the wife's allegation that the marriage is irretrievably broken. The court may then grant a stay of proceedings for up to 3 months and may also order the parties to go to counseling. However, this is not mandatory. The judge will not force the parties to go to counseling if they do not wish to go. Equitable distribution. During the divorce proceedings, the court will look at the assets of the parties and distribute them among the parties. The court will first separate marital from non-marital assets and distribute only those assets that it determines to be marital. Marital assets are interspousal gifts and other assets the parties obtained during the marriage, with marital funds or due to marital efforts, regardless of whether they are jointly titled or titled in the name of one spouse alone. This includes tangible assets and vested and non-vested intangible assets such as retirement accounts and pensions. Non-marital assets are assets that were acquired by either party prior to the marriage, or gifts, bequests, or devises given to one spouse alone by someone other than their spouse. Other assets or compensation received in exchange for non-marital assets as well as passive appreciation. Appreciation due only to market forces of non-marital assets retains its non-marital character. However, active appreciation due to the marital effort of either spouse, is marital. Parties also have to be careful to maintain their separate property separate and not commingle it with marital assets. Non-marital assets remain with their respective owners. The court starts from the position that distribution should be 50-50 unless there is some reason shown to support an unequal distribution. Some factors the court will consider in determining whether there are grounds for unequal distribution are the age, physical, mental, and emotional health of the parties, their earnings and earning capacity, their education, whether either party been unemployed, whether either of the parties have been the primary caretaker of the children, and the assets of the parties. Of course, the court has discretion to consider any other factor that it deems appropriate to bring equity between the parties. While the court does not consider alleged infidelity as grounds for divorce, it may consider it an equitable distribution, especially if there has been dissipation of marital assets as a result. The court may award specific assets to one or each of the parties, and it may also order cash equalizer payments. Marital home. Generally, a home purchased by a married person is titled in the name of husband and wife as tenants by the entireties. Pension. Marital assets include vested and non-vested retirement accounts and pensions. The husband receives a military pension for his 20 years of service. Alimony. The wife has requested alimony. There are different types of alimony in Florida. Alimony pendant light, bridge the gap, rehabilitative, durational, and permanent. Alimony pendant light is also known as soup money and is available to either party during a divorce. This is a temporary award of alimony designed to help the recipient maintain the status quo during the pendency of the divorce. Bridge the gap alimony is a short-term alimony award designed to help the recipient make the transition from being married to being single. This award may not exceed 2 years and it is non-modifiable, but it terminates upon the death or remarriage of the parties. Rehabilitative alimony is also a short-term award. It is designed to help the recipient obtain necessary education or work experience in order to become self-supportive. This award is for a set period of time and comes along with an educational or training plan. It is modifiable upon a substantial change in circumstances and may be terminated upon the death, remarriage of the recipient, or if the recipient fails to follow the plan. Durational alimony is awarded where permanent alimony is not appropriate. This is generally for short-term marriages, less than 7 years, to moderate-term marriages, between 7 and 17 years of marriage. Durational alimony is awarded for a set period of time not to exceed the length of the marriage. Permanent alimony is awarded when the recipient is unable to financially support him/herself. This is generally more appropriate for long-term marriages, those exceeding 17 years. It may also be awarded in moderate-term marriages upon a showing of need and ability to pay by clear and convincing evidence, or in short-term marriages supported by a written finding by the court of exceptional circumstances. Awarding alimony. In determining an award of alimony, the court determines the recipient's need and the payer's ability to pay. The court will also consider the age, physical, mental and emotional health of the parties, their earnings and earning capacity, their education, whether either party has been unemployed, whether either of the parties have been the primary caretaker of the children, the age of the children, and the assets of the parties. The court will also look at marital misconduct, such as infidelity, dissipation of marital assets, or abuse. Parental responsibility. The court starts from the position that parents should have shared parental responsibility. This means that both parents should share equally in the rights, responsibilities, and joys of raising their children. Generally, courts will award shared parental responsibility unless it will be detrimental to the child. The standard court will use in making such a determination is in the best interest of the children. Each party has a right to participate in making decisions for health, education, religious, and other needs of their children. Each party must seek the participation of the other in making such decisions. Timesharing. Timesharing must also be awarded in the parenting plan. This includes overnight and holiday visitation, and it is also awarded based on the best interest of the 7 children. The court starts from the position that each parent should get 50-50 timesharing with the children, unless it is reason to award more or less time to one parent. There are no presumptions that either mother or father are better suited to have primary time sharing. The court will look at factors such as the age of the children, the desire of the children, if they are old enough to express it, the fact that the mother has been the primary caretaker of the children, whether the father's work schedule will interfere with his ability to enjoy timesharing with the children, and any other factor the court deems necessary to support the best interest of the children. Child support. Child support is calculated irrespective of timesharing and parental responsibility. Whether or not a parent enjoys timesharing or parental responsibility, they are still responsible for supporting their children. Child support calculations are based on statutory guidelines. The amount is based on the net income of the parties, the number of children, and the amount of time sharing each parent enjoys. the court may deviate upward or downward from the guidelines by 5%. A greater deviation would have to be supported by written findings. A parent that enjoys 20% or more overnight timesharing will also be able to get a reduction in child support. In addition to making a child support calculation, the court will have to indicate in the parenting plan which parent will be responsible for providing health care coverage for the children and how uncovered medical expenses and other out-of-pocket expenses will be divided. Divorce. Florida has eliminated fault-based divorce. In Florida, a couple may divorce if 1, the marriage is irretrievably broken down, or 2, if one spouse becomes mentally incompetent. For a divorce predicated on an irretrievable breakdown, only one spouse need believe that the marriage is irretrievably broken. Moreover, the court may continue the proceedings for 3 months to allow for the couple to reconcile. For a court to have subject matter jurisdiction over a divorce, only one party need be a Florida resident. Alimony. In Florida, both spouses are responsible to financially support one another. Alimony is determined based on the financial needs of one spouse and the ability of the other spouse to pay. There are several different types of alimony that are currently available in Florida. 1. Temporary alimony. This type of alimony is used for the spouse needing the support while the dissolution proceedings are going on. 2. Bridge the gap alimony. This type of alimony is used to bridge the gap from married life to single life. 3. Rehabilitative alimony. This type of alimony is provided so that the needing spouse may develop the necessary skill set via education and training so that they could find proper employment. 4. Durational alimony. This type of alimony is designated for a specific period of time. However, it is not available for marriages that have not lasted for at least 17 years. 5. Permanent alimony. This type is fixed. Many factors are considered in determining whether to provide alimony. Some of these factors include age of each spouse, duration of marriage, current income of each spouse, other sources of income for each spouse. Child support. Both spouses have an obligation to support their children. Florida uses an income-based share plan to award child support. The court is entitled to deviate 5% from the guidelines without stating a reason. Custody/parent planning. In Florida, the court develops what is known as a parenting plan. This plan includes 2 portions: 1, time sharing, and 2, parental responsibility. There is a presumption that the child should spend equal time with each parent. However, the superseding factor is always what is in the best interest of the child. Under a time-sharing plan, both parents should have equal time with each parent. However, certain factors may come into play, such as who raised the children, where they go to school, where they want to stay, if they are at an age where they could understand such a decision. There are many other factors in making this determination. The second prong, parental responsibility, includes 2 types: ultimate responsibility and parallel parenting. Under ultimate responsibility, each spouse is solely responsible for a certain responsibility, i.e. schooling or medical. Under parallel parenting, those responsibilities are shared. Relocate with kids. If one spouse intends to move more than 50 miles away, he or she bears the initial burden of proof. She must show that based on numerous factors, such as job opportunity, child's choice, depending on age, and other such factors. If moving, the moving spouse must provide the new address, how time sharing will continue to work, among other requirements. The burden then shifts to the opposing spouse to show why the move would be improper. Distribution of assets. Florida utilized equitable distribution. Under this doctrine, distribution of assets is not necessarily controlled by title. The assets are first identified, then assessed, and then distributed in an equitable manner. How the assets are distributed, i.e. what portion to whom, is determined by a variety of factors, namely income, need, duration of marriage, among others. Assets that are separate include those that were owned by the respective spouse prior to the marriage, or gifts or devises to one specific spouse before or during the marriage. Assets acquired during the marriage, or any appreciation, due to some sort of contribution from the other spouse, not just by virtue of the market, to separate assets during the marriage are considered marital assets. It is the marital assets that are then assessed and divided. Life insurance. Life insurance policies are essentially will substituted, which terminate by law upon divorce. Jurisdiction. In order for a party to file this type of action in a Florida court, the party has to be living in the state for at least 6 months. In order for the court to have personal jurisdiction over the opposing party being served, the party must either be a resident of the state, or there must be a basis for personal jurisdiction pursuant to Florida's long-arm statute. Florida's long-arm statute analyzes the party's contracts in the state, for example, whether the party owns property or does sufficient business in the state. When an action involves a child, jurisdiction will be based upon the Uniform Child Custody Jurisdiction Enforcement Act, UCCJEA. The state that issued the first order regarding the child will always have continuing jurisdiction to modify it. However, jurisdiction could also be established in the state where the child and at least one parent have resided for the last 6 months. If this cannot be established, Florida could still take jurisdiction if no other state wanted to take jurisdiction of the case. Time sharing. In Florida, the court enters what is called a parenting plan in order to address every detail regarding time sharing. This parenting plan includes the time each parent will spend with the child, the extracurricular activities the child will participate in, travel arrangements for time sharing, who makes decisions over the children, whether those decisions will be shared, and every other issue that would affect the well-being of the children and affect their best interests. This parenting plan is normally referred to in the parents' marital settlement agreement when there is a divorce, and is, therefore, incorporated into the final judgment. Modification of time sharing. In order to state a proper claim for modification of time sharing, the party seeking the modification must allege a substantial change in circumstances that is permanent, involuntary, material, and unforeseeable at the time of entry of the final judgment. The best interests of the child always govern. Although Florida statutes provide a lengthy list of factors that are considered when analyzing the best interest of the child, the usual factors that are mostly used by the court are continuity for the child, how likely the other parent is to encourage and foster a meaningful relationship with the other parent, the child's preference, which is weighed heavily when the child is still a minor, but older and able to express himself regarding his wants and needs, the ability of each parent to care for the child, and any past history of substance abuse, or any other type of abuse. Parental responsibility. In Florida, there are 3 types of parental responsibility. Shared parental responsibility is when both parties are charged with equal decision-making over the children. Anything related to the children, including their medical treatment, schooling, and upbringing, would be jointly decided by both parents. This is the norm, as both parents have a constitutional right in Florida to participate in the upbringing of their children and in the joy of child rearing. Sole parental responsibility. Sole parental responsibility is given to only one parent when it is found that the other parent is a detriment to the children or is otherwise unfit and unable to provide care for them. This vests all of the power to decision-making over the children in one parent. 10. There is also parallel shared parental responsibility, where the responsibility is split, but according to subject. This is especially applicable when one parent has a special skill that should entitle him or her to handle decisions relating to that skill. For example, if one parent is a doctor, the court could allow that one parent to make all of the decisions regarding the children's medical care. The other parent, who could be a teacher, for example, could handle decision-making in the area of the children's schooling. This gives the parents shared parental responsibility, but according to topic and subject, rather than as a whole. Modification of shared parental responsibility. In order to modify time sharing, the court has to weigh the parent's constitutional right to participate in the upbringing of their children and balance it against the weight of the best interests of the children. The standard for determining the best interests of the children is described above. The person seeking the modification must allege a substantial change in circumstances, as well as factors that would render the parent unfit and detrimental to the children. Child support. In Florida, both parents are obligated to contribute to the support of their children, regardless of whether they are married, separated, divorced, or were never married at all. Child support is primarily based on need and ability to pay. The court will look at the respective income of both parties, the health insurance that is being paid for the child, the necessary childcare costs, and the time sharing being exercised by both parents. Florida has statutory guidelines regarding what child support should be based on the parent's income. If one parent is spending more than 30% of the time with the child, then child support is calculated using a gross-up method, which gives that parent with a substantial amount of time sharing a higher amount. A court can deviate only up to 5% away from the child support guidelines after considering relevant factors, and with specific findings of fact, that would justify the deviation. Modification of child support. In order to seek a modification of child support, the party seeking the modification must allege a substantial change in circumstances. The change would need to be one of the factors that is used to calculate child support, income, healthcare costs, childcare costs, and/or time sharing. The modification would date back to the date of the filing of the petition. This means that, if child support is modified to a higher amount, the difference between the established amount and the new higher amount would be collectible from each month from the filing of the petition through the date that judgment is entered. Bank account. The money that is held in the savings account is in both names and presumed to be held in TBE. Therefore, without some reason for its protection, the money may be garnished by the judgment creditor. However, in Florida, wages of the head of household are exempt from garnishment for 6 months after they are received, even if placed in a bank. If the funds are commingled, they lose their protection to the extent they cannot be traced. Therefore, one of the parties would have a right to claim exempt the money that could be traced to their wages if they so claim after a writ of garnishment 9 is issued and they can establish that they are the head of household, which requires a showing of providing 50% or more support to a dependent, the other spouse in this instance. Additionally, in Florida, homestead exemptions, not real property, include a $1,000 exemption for personal property. Therefore, they may claim this exemption as well. Homestead. Article X Section 4 of the Florida Constitution exempts from execution and forced sale by creditors up to 1/2 acre of contiguous land within a municipality and up to 160 acres of contiguous property outside of a municipality if the property is a homestead. To establish a homestead, an individual must be a Florida resident and must have intent to establish that place as their home and actually live there. There is a strong presumption of protection of homestead, and courts construe the law to permit the claiming of a homestead where the facts can establish one. Once homestead is established, it may be abandoned if the homesteader leaves the property with the intent to no longer make it their regular abode. A party may have only one homestead, and it is a requirement that party live there and establish homestead prior to the attaching of the lien by a judgment creditor, lien attached at time of recording as explained above. Homestead rights created by the Florida Constitution are construed to protect the family home. Therefore, the property is likely the homestead of D's ex-wife and child. A person, especially a minor child, doesn't have to own the property to have homestead protections. The protections simply must exist prior to the lien on the property. Time sharing. Florida follows a statutorily enacted scheme for timesharing, no longer called custody, of marital children. The timesharing plan is one part of a parenting plan. Florida requires that a parenting plan be prepared and filed with the court in any action for dissolution involving minor children of the marriage. The parenting plan must provide for how major, and some specifically referenced minor, decisions are to be made. There is a presumption of shared decision-making by both parents with respect to the minor child. Furthermore, the parenting plan also contains child support that is required to be paid for the support of the child based on Florida's child support guidelines. Florida starts with the presumption that shared timesharing is in the best interest of the child. All decisions that are contested regarding timesharing are to be made on that standard. Timesharing factors. There are a number of factors that are used in determining what timesharing schedule is appropriate for a minor child if a schedule cannot be agreed upon. Included in these factors are the age of the child's preference, one parent's apparent ability to provide a stable living situation for the child, the parent's ability to abide by the timesharing plan and foster consistent contact with the other parent, the geographic locations of the parents, the work schedules of the parents, and any other factors that would be in the best interest of the child. Courts must approve relocation of a parent when the parent is relocating out of state. Jurisdiction. There exists in Florida, and throughout the United States, a Uniform Child Custody Jurisdiction Enforcement Act, UCCJEA/the Act, that provides that all courts must abide by any order of the court that had original jurisdiction over the parties and their minor children. Distribution of the assets. Florida follows a scheme of equitable distribution of assets. There is a presumption that the parties' marital assets will be distributed equally in a dissolution action, but this presumption may be overcome and assets may be unequally distributed based on a number of factors. In determining equitable distribution, courts must first divide the assets into marital and non-marital classifications. Marital assets include all assets obtained by the parties during the marriage except those that were given by bequest or devise to one party. This normally includes, among other things, income on investments, earnings, gifts between spouses during the marriage, and increases in retirement and savings plans during the marriage. Non-marital assets are those that were separate before the marriage and maintained their status as separate during the duration of the marriage, as well as any inheritance, bequest, or gift to one spouse during the marriage that is not somehow converted into a marital asset. Equitable distribution factors. In determining whether to distribute the assets unequally, the courts may look at the following non-exclusive list of factors: the parties' contribution to the marriage, including that of rearing the children and homemaking, whether there are any minor children of the marriage, depletion of assets of the marriage by one party, i.e., on a mistress, the parties' respective ability to provide for themselves after the marriage, including age, physical and mental disability, education, potential for employment, and any other factors necessary to do equity. Tenancy by the entirety. In Florida, this creates a presumption of tenancy by the entirety when parties are married and title a home jointly. This means that each party owns an undivided 100% interest in the home. A tenancy by the entirety can be converted to a tenancy in common if the parties divorce. This is effective at the time the divorce decree and final judgment is entered, not merely when the petition for dissolution is filed. A co-tenancy that is a tenancy in common may be monetarily divided by a partition and sale required by the court. The court may order a partition and sale and distribute the proceeds from the sale, less any mortgage exoneration issue discussed later, equally, or unequally if W or H presents evidence for an unequal distribution, to the parties. Money market account. The money market account was also titled jointly. Again, this creates a presumption that it belongs to both parties of the marriage. Marriage debts. In Florida, any debts or assets acquired after a petition for dissolution of marriage is filed is considered the sole debt or asset of the person acquiring it. Homestead. The Florida Constitution provides special rules and protections for homestead property. Homestead property is defined as up to 160 contiguous acres in a county, outside a municipality, including improvements thereon, or 1/2 an acre inside a municipality that includes only the home thereon. Homestead property is exempted from forced sale by creditors, except for tax liens, mechanics liens for improvements to the property, and mortgages on the property. In Florida, regardless of how the property is titled, a spouse may not mortgage or convey the home to a third party without the express written consent of the other spouse. Modification of spousal support. In Florida, to seek a modification of spousal support, alimony, the FW must show that a change in financial circumstances that are permanent and not contemplated at the time of the entry of the FJ. The central prong in alimony reduction requests is the decreased ability of the payer spouse. Modification of alimony. In Florida, if the needs of the FW are no longer present for the permanent periodic alimony, the FH can seek to reduce and/or terminate his alimony. Cohabitation statute. Florida has adopted a cohabitation statute that provides the paying spouse a vehicle to terminate alimony when it can prove the elements therein. Usually, permanent alimony remains for the life of either party, or until the remarriage of the receiving spouse. This statute provides the alternative means to terminate an award of alimony. These include the parties, FW and boyfriend, holding themselves out as a married couple, the creation of joint accounts with the intent of being classified as marital, the living exclusively under the same roof, the structure of their financial pictures, i.e. allocation of household expenses, and the title of both personal and real property, as well as the years the parties have engaged in this behavior. Retroactive calculation of his spousal support payments. Florida defines the cutoff date for the application of a downward modification of spousal support to be the date upon which he files his supplemental petition. Modification of child support. Florida courts define child support as being for the benefit of the minor children. To seek a modification of termination, the standard set must be met, namely, that again there is a change in financial circumstances that were not present at the time of the FJ, the change was not contemplated at the time of the FJ and the change is permanent. Florida further permits under statute a modification either upward or downward, when it can be shown that the change in circumstances would result in a 15% or $50 change in the Florida statute child support guideline amount. Florida courts generally state that when the FJ is silent as to the reapportionment of child support upon one of the children coming off the guidelines, that there is no automatic reapportionment of the support for the remaining children. In Florida, courts generally allow child support to continue past the age of 18 of the minor child if there is a reasonable expectation of graduation by the time the child will turn 19. This works with the general premise that the support of a child ends at 18, dies, or otherwise becomes emancipated. Homestead. There is a presumption that minor children should be given the most stable environment possible, and one aspect of that stability is the house in which they live. As such, the primary residential parent may be entitled to continue living in the house with the minor children. If there are no minor children, the property may also be divided other than 50/50ths during equitable distribution. There are special rules regarding the family's homestead. It cannot be conveyed if the decedent is survived by a spouse or minor children, except that it can be conveyed to spouse if there are no minor children. Equitable distribution. Equitable distribution is the court deciding the property rights of each ex-spouse to the marital property accumulated during their marriage. The beginning presumption is that each spouse will be entitled to an equal share, but a court may award unequal shares if that would be more fair by looking at statutory factors in favor in unequal distribution. A court may also consider the desirability of keeping an asset intact, such as a business or the family home, and may order that one spouse pay a lump sum of alimony or that he makes periodic payments to equalize the shares. Judgment of dissolution. A final judgment of dissolution of marriage serves to settle the property rights and responsibility for debt of the parties, and may govern alimony, child support, and child custody and visitation. Where the parties have no minor children and they agree on a division of assets and debts, they can file for divorce in an expedited proceeding in the county courts. Divorce. Florida is a no-fault divorce state. In order to dissolve a marriage, all that is required is that the marriage be irretrievably broken. If one party does not want to end the marriage and there are no minor children, the court can order counseling and continue the proceedings for 3 months to see if a reconciliation can be effected. If the wife does not want the divorce, she can go to counseling, but the divorce will be granted if a reconciliation cannot be effected. In addition, if a party is mentally incompetent for more than 3 years, a divorce can be obtained even if the marriage is not irretrievably broken. Prenuptial agreement. Prenuptial agreement in a writing that satisfies the statute of frauds will be upheld so long as there was no undue influence, fraud, or duress in entering into the agreement. There is sufficient consideration for the agreement by the agreement to enter into the marriage. There may be indicia of undue influence, fraud, or duress if the timeframe between presenting the agreement and signing it is short or if the spouse did not have an opportunity to consult counsel. Equitable distribution. Florida is an equitable distribution state. The marital assets will be divided 50/50ths unless there is a claim for unequal distribution. The court must first determine what the marital assets are. Marital assets include 1. Anything acquired during the marriage by either one or both spouses, except for a gift, bequest, descent to one spouse. 2. Enhancement of or appreciation in value of non-marital assets because of the contribution from one or both of the spouses or because of contribution of marital funds. 3. Interspousal gifts. And 4. Benefits accrued during the marriage and retirement plans, 401k, pension plans, and profit-sharing plans. Equitable distribution factors. Florida courts follow the statutory guidelines for equitable distribution. Factors taken into account to make the equitable distribution are 1. Contribution of each spouse to the marriage, 2. Contribution of each spouse to care and education of children, 3. Contribution of each spouse to homemaking services, 4. The financial sources and resources of each spouse, 5. The duration of the marriage, 6. The need for a spouse to maintain an asset free from interference from the other spouse. Homestead. In addition, in Florida, a natural person who owns a home can claim a homestead in the home if there is residence. They are entitled to protection for 1/2 acre within a municipality and up to 160 contiguous acres outside a municipality. The homestead cannot be sold, gifted, or mortgaged without the consent of both spouses. Alimony. Alimony is awarded based on each spouse's need and ability to pay. In Florida, there are statutory guidelines for alimony awards. There are 4 types of alimony that can be awarded in Florida. Temporary alimony during the pending litigation of the dissolution. It cannot be waived by agreement. Permanent periodic alimony available for the maintenance and support of a spouse that does not have the ability to be self-sustaining. It can be modified upon a substantial change of circumstances. This type of alimony can be waived in a prenuptial agreement. Rehabilitative alimony is for the education and training of a spouse that needs it to become self-sufficient. Lump sum alimony is a definite sum paid one time or in periodic installments. It is final and can be used to achieve an equitable distribution of property. It is final and payable even if the payer spouse dies. Alimony factors. The factors that a Florida court considers to determine an award of alimony are 1. Standard of living during the marriage, 2. Duration of the marriage, 3. Age, physical and mental condition of the parties, 4. Financial sources and resources of the parties, 5. Education and career sacrifices made by either spouse, 6. Contribution to the marriage in the form of homemaking services, care of children and contribution to the marriage, and 7. Any other factor that will promote equity. The court may also look at adultery on the part of one party in making the alimony determination, but only if it resulted in depletion of the marital assets. Divorce. A spouse, who is a resident of Florida for at least 6 months prior to petitioning for divorce, may petition the court for a divorce on the following grounds: the marriage is irretrievably broken, or the other spouse has been adjudicated mentally incompetent and has remained so for the past 3 years prior to petition. Henry would have stated the irretrievably broken grounds for divorce. This divorce would not be entitled to summary proceedings in county court because there is real property and a minor child, Chris, and so it must be filed in circuit court. Equitable distribution of marital assets. Upon the petition for divorce, the court is required under Florida law to distribute the marital assets under the equitable distribution doctrine. In order to do so, the court must first distinguish between marital and non-marital assets. The latter are kept by the individual owner spouse. Non-marital assets are those which were acquired before the marriage, and individual gifts to one spouse only, inheritance, for example. Marital assets are those that were acquired during the marriage, the value of improvement of real property during the marriage, even if the home itself is non-marital, as is the case here, interspousal gifts, all income, and earnings during the marriage. The court must divide the property equitably, and will generally attempt to achieve a 50-50 split, half to each spouse. However, the court is allowed to alter the distribution percentage if equity so requires. The court will consider factors such as the following: the standard of living of the spouses during the marriage, the economic status of each spouse, the physical and emotional health of each spouse, the contributions made to the marriage by each spouse, both economic and emotional, the length of the marriage, anything else equity requires. Alimony. Alimony is the extension of the spousal obligation to support the other spouse. Florida courts are allowed to grant one or more of the following 4 types of alimony. 1. Temporary, during the pending divorce proceeding, up to 3 months if the court extends for contested proceedings. 2. Lump sum, designed to be a liquidated amount of the total support that would be paid to the spouse for the spouse's life expectancy. 3. Permanent periodic payment. These are periodic payments made on usually a monthly basis, that are permanent until the spouse remarries or dies, or potentially lives with another person who is supporting the spouse. 4. Rehabilitative, designed to reimburse the spouse for illness or education. If the spouse gave up work or schooling for the marriage, may be reimbursed so that they can re-enter school. Alimony factors. The court, in its equitable discretion, will consider the following factors when making an alimony decision: the standard of living of the spouses during the marriage, the economic status of each spouse, the employment status of each spouse, the physical and emotional health of each spouse, contributions made to the marriage, the ability of the petitioning spouse to support his or herself, the need for a spouse to go back to school or go to school in order to become employable again. Anything else equity requires. Shared parental responsibility/custody. In Florida, the court will follow the best interest of the child standard, BIC, in determining the custody arrangement of the minor child. The court prefers to grant both parents shared parental responsibility shared for the child as well as decisions in the child's upbringing, etc. shared, and will generally grant primary residential custody to one parent and liberal, reasonable visitation to the non-residential parent. The court, in determining the BIC, uses the following factors: the desires of the parties, and minor child if 12 years old or older, the economic and emotional stability of the parents, the ability to provide a loving environment for the child, the likelihood that placement with one parent would result in that parent inhibiting or creating obstacles to the other parent's visitation, history of domestic abuse, any other matters equity requires. Child support. The Florida statute sets out the child support guidelines and is based on the income of each parent and the number of children. Child custody. Child custody is a bitter issue that is inevitable when dealing with a divorce involving a child. Both parents have equal obligations for support of the child. More importantly, each parent has the right to visitation of the child. The court also has the authority to require that a parent granted physical custody must foster a loving relationship with a non-custodial parent. Physical custody of the child is not to be confused with parental custody. The court will commonly award shared parental custody, which gives both parents the equal right to make important decisions involving the child's medical treatment, education, and welfare. Furthermore, even when a court awards only one parent with physical custody, the other parent has a right to visitation. The court will commonly award visitation and enforce it without restrictions absent a showing of wrongdoing, abuse, or other relevant factors suggesting that supervised custody would be preferred. Finally, the court will generally allow a parent with physical custody to freely move and relocate absent a special provision in the child custody agreement requiring prior court approval or restrictions. However, the initial child custody agreement is not permanent. Upon a showing of substantial change, the court may issue a child custody modification. Jurisdiction. In order to greatly facilitate the decisions and custody hearings that are in the best interest of the child, all states have adopted the Uniform Child Custody Jurisdiction and Enforcement Act, UCCJEA. This act allows for a continuing and standard jurisdiction for proceedings dealing with child custody enforcement and modification. In applying the UCCJEA, the first question revolves around the establishment of the correct home state. The home state is the state where the child and one parent have lived for a continuous 6 months just prior to the filing of the present action. A home state may also be the state where the child and parent had a previous home state, domicile of the child and one parent for a continuous 6 months just prior to the filing of the present action, if it was the home state within the last 6 months and one parent still resides there. Nevertheless, the home state jurisdiction is not always exclusive. One exception to the general home state rule is when a state has a significant connection and substantial evidence with the child custody dispute. Furthermore, a foreign court may also refrain from exercising jurisdiction when the focus is inconvenient or if another state's court would more adequately be able to decide the case. Finally, the UCCJEA also states that the court where the original child custody 5 agreement was procured will exercise exclusive continuing jurisdiction for as long as there is at least one parent still in the jurisdiction and the state has a significant connection and substantial evidence with the child custody agreement and need for modification or enforcement. Relocation. Absent a particular provision in the original child custody agreement, the physical custodian of the parent is free to relocate from one place to another. However, this right is not conclusive. The court will take into consideration what would be in the best interest of the child. The court will also take into consideration the non-physical custodian parent's rights to visitation and relationship with the child. Furthermore, the court will consider the reasons and motives behind the relocation. Sole custody. As noted above, a child custody arrangement is not conclusive and may be modified upon a showing of a substantial change in circumstances. When making a modification ruling, the court will continue to use the same judgment and discretion when deciding the original decision. The court must consider what is in the best interest of the child. Equitable distribution. Florida follows the theory of equitable distribution and favors a presumption of an equal, 50-50 split of the marital assets. However, the court can take into account certain factors and deviate from the 50-50 presumption when justice and equity requires it. In determining the division of marital property, the court must first determine what the marital property is. In Florida, marital property is any property acquired during the marriage by either party with the exclusion of gifts or bequests that are kept separate and not commingled. Marital property typically includes the spousal income and earnings during marriage, appreciation in the assets of the marital property, pension and retirement benefits, and any interspousal gifts. Non-marital property remains the property of the individual spouse and consists generally of property owned or received before marriage as well as property received by the individual spouse via an inheritance or gift during the marriage. Special equity. Special equity is the court's recognition of one spouse having a special individual interest in the property due to specific acts the spouse performed that were beyond that typical of normal marital duties. Deed transfer. Florida requires that the deed instrument be in writing and signed by the party to be charged as well as signed by 2 witnesses. Equitable distribution factors. In determining equitable distribution of the marital funds, the court will consider several factors including the length of the marriage, the contributions of each spouse to the marriage and the marital property, any special equities earned by one spouse by going above and beyond the call of marriage, as well as adultery, to the extent the relationship depleted marital funds, and anything else that would justify an equitable result in the final distribution. Permanent periodic alimony. Permanent periodic alimony is designed as permanent assistance to the spouse that is less self-sufficient and needs financial support to maintain himself/herself. The court will typically consider the length of the marriage, the age and physical abilities of the parties, any education, standard of living the parties have become accustomed to, as well as the parties' ability to be self-sufficient. Prenuptial agreement. Under FL law, parties may validly enter into postnuptial agreements or prenuptial agreements. A postnuptial agreement is where the parties mutually and voluntarily agree to enter into a contract post-marriage to divide assets, determine child-related issues, or any other issue the parties desire, that will take effect upon dissolution of the marriage. In determining whether a postnuptial agreement is valid, the court will consider the following. Was the agreement between the parties voluntary and made without any duress or undue influence? Did the parties have an opportunity to consult independent counsel? Was there an imbalance of power between the parties such that one party has much greater leverage over the other party? If a party waived probate rights, was there full financial disclosure to the waiving party? Waiver of alimony. In addition, a party may validly waive any claim to alimony via a postnuptial agreement, as long as the waiver is express and completely voluntary. However, a party cannot waive the right to child support, because child support is a right individual to a minor child because she has the right to support until age 18 or up to 19 if she is still in high school. Equitable distribution. Under FL law, in the absence of an agreement between parties, the presumption is that the court will divide marital assets/liabilities under an equitable distribution scheme, presumptively a 50/50 division. Unless a party proves a special equity contribution beyond a normal marital contribution, the court will divide the assets equally. The parties have agreed in their postnuptial to equal division, which complies with the law. Alimony. There are 4 types of alimony: permanent periodic alimony, rehabilitative alimony, temporary alimony, and lump sum alimony. Permanent periodic alimony is used for a spouse that does not have the ability to be self-sufficient and usually applies when the parties have been married long-term, i.e. at least 16 years. Rehabilitative alimony is appropriate when a party has the ability to become self-sufficient via education or vocational training. Lump sum alimony is only appropriate when there are special circumstances such as the threat that the payer spouse might die or become physically unable to continue paying alimony. Lump sum alimony is a vested right once it has been awarded. Temporary alimony is alimony paid to a needy spouse during pendency of divorce proceedings. Child support. Child support is a right that cannot be waived in a postnuptial agreement. Every child under age 18 or up until 19, if still in high school, has a right to be supported financially from both parents. An award of child support in FL is determined by applying the statutory child support guidelines, which is based on income of both parents, and other statutory factors such as disabilities and health care needs of the child, the parent's other child support obligations, etc. Custody and visitation. Child custody and visitation in FL is based on the following factors: ability of each parent to support the child and provide the child necessities, the preferences of the child, the preferences of the parent, and the parent most likely to encourage visitation with a non-custodial parent, and the child's connections with a particular parent. FL courts presumptively disfavor rotating custody. In FL, one parent is usually the primary residential parent, while both parents usually retain shared parental responsibility for major decisions regarding the child's education, religion, etc. Divorce. Florida is a no-fault divorce jurisdiction. A divorce may be granted where the parties contend that their marriage is irretrievably broken. However, where there are minor children or where one of the parties contests that the marriage is irretrievably broken, the judge may order the parties to undergo marriage counseling. Equitable distribution. Florida is an equitable distribution jurisdiction. This means that marital property is divided equally among the parties, 50/50. However, where 50/50 distribution is not appropriate, i.e., where it would be inequitable, for example, the court may divide the property so that it is fair and equitable to the parties. For example, the court can consider any party's interest in a particular piece of property such as a business or sentimental valued property. Also, the court may consider one party's desire to retain the marital home. Note that the court can order that the primary residential parent may retain the home until the children reach the age of 18 and then order the sale of the home for equitable distribution. In order to effectuate equitable distribution, the court must first distinguish marital and non-marital property. Marital property. Marital property is property, including debts, during the marriage, interspousal gifts, enhancement, or appreciation of non-marital property by the efforts of either spouse during the marriage. Non-marital property. Non-marital property is property, including debts, acquired by either spouse before marriage, non-interspousal gifts, bequest, or devise. Alimony. In Florida, there are 4 types of alimony. Alimony can be requested by either party in a divorce proceeding. In determining whether to award alimony, the court may consider, among other things, the duration of the marriage, age of the parties, financial need, adultery. However, note that adultery cannot be the basis for awarding or denying alimony unless the adultery depleted marital assets, standard of living during the marriage, contribution to the marriage, need for rehabilitation, i.e., Allow the recipient spouse support so that she/he can become self-sufficient. Permanent periodic alimony. This type of alimony is paid to a spouse in permanent periodic payments. This type of alimony is modifiable upon a showing of substantial change in circumstances. It terminates upon the death of either party or upon the remarriage of the recipient spouse. Temporary alimony. Temporary alimony is paid during the pendency of litigation. Lump sum alimony. Lump sum alimony is paid in one lump sum. Typically, it is available where there is a showing that the spouse is in ill health, and permanent periodic alimony will not serve its purpose if there is extreme hostilities between the parties. Rehabilitative alimony. Rehabilitative alimony is alimony paid to the recipient spouse for a reasonable period of time for the purpose of rehabilitating that spouse back into the workplace so that the spouse can become self-efficient. Child custody. Child support and custody are always determined under the best interests of the child standard. Both parents are responsible for the support of their children. There is no presumption in favor of any parent, husband or wife, could be awarded custody. Always considering the best interests of the child, the court may also consider among other things the following: ability of parent to provide necessities to the child, food, clothing, shelter, desirability of continuity, the child's preference, if of an adequate age and understanding, the likelihood that the parent will comply with visitation and foster a loving relationship with the other parent, fitness of the parent. Generally, the court will not split the children up. It is in the best interests of the children to remain together, since they always have, and this would force continuity for the children, and also this would allow the children to have each other for support. Child support. In Florida, child support is awarded pursuant to the statutory guidelines taking into account income and number of children. The duty of child support continues until the child reaches the age of 18, or can continue if the child has a disability or is still in high school from age 18 to 19. There is no obligation to continue support for the children's college education, although the parties may expressly agree. Income may be imputed onto a parent if the parent is voluntarily unemployed or underemployed. A judge may deviate from the guidelines by 5%, however, a deviation beyond 5% must be accompanied by writing findings justifying such a deviation. A judge must deviate by 5% if the child spends a significant amount of time with the payer spouse. A child support order must also contain a provision proving medical insurance for the children if it is reasonable ascertainable. Child support modification. Child support is modifiable upon a showing of a substantial change in circumstances. Equitable distribution. Under Florida law, marital property is distributed under the doctrine of equitable distribution. Equitable distribution requires that property is divided 50-50 unless justice requires otherwise. In Florida, marital property includes 1. Assets accrued during the marriage, 2. Interspousal gifts, 3. Pension plans, etc. In determining the distribution of property, the court considers the following factors: the background of the parties, letting the spouse go to school, longevity of the marriage, saving the marital home for the kids, the health of the parents, interruption of careers. Alimony. Under Florida law, a spouse may receive alimony based on their need and the other spouse's ability to pay. Florida recognizes 4 types of alimony: 1. Periodic permanent, 2. Lump sum, 3. Rehabilitative, and 4. Temporary. In determining whether to award alimony and the amount to be awarded, the following factors are considered: the spouse's contribution to the marriage, time needed to acquire training and education to re-enter the workforce, the age, emotional and physical conditions, financial resources, and duration of the marriage. Adoption. Under Florida law, a natural person who is a Florida resident and capable of care-giving may adopt child. However, homosexuals may not adopt in Florida. Furthermore, consent of the parents is required unless the parent abandoned the child. Child custody. Under Florida law, the best interest of the child standard is applied in determining custody. The court also considers factors such as the best interest of child, the child's preference, the health of the parties, institutions such as schools and churches, pecuniary welfare, other siblings, and one's ability to comply with the court's visitation order. Child support. Under Florida law, each parent is equally responsible for the care of their child. However, the court must follow statutory guidelines in determining the amount of support Howard will be required to pay. If the judge deviates from the guidelines by 5% or more, justification must be provided in writing. Parent consent. As to daughter, uncle needs both the husband's consent and the daughter's consent because she is over the age of 12. Regardless of her age though, Florida does not have an age at which children have the absolute right to consent to family law proceedings. Grandparents' rights. Florida gives protections to grandparents. Grandparents here would have a right to receive notice of the TPR proceedings. They also would have rights to challenge an adoption by the uncle. They have preference rights such that they might have a better case for being assigned custody of the children. In Florida, grandparents would also be entitled to visitation rights to the children while in the mother's care, and if put into custody in anyone else's care.